All right. Good evening once again, ladies and gentlemen. We're now going to discuss Chapter 6, Searches and Seizures of Property. As an introduction, the Supreme Court has expressed a preference for warrants, and you're going to hear that over and over again in these chapters. There's a preference that the law enforcement just go get a warrant. The court has recognized the reasonableness of several types of warrantless searches. So we're going to talk about some exceptions to the warrant rule. Search warrants. A search warrant is based on probable cause. If we state as you're going to hear ad nauseum, probable cause. Probable cause is based on an probable cause is based on an affidavit submitted by a police officer in support of his warrant. So they have to submit an affidavit actually sworn to it. So the officer is actually going to be sworn in front of a judge to the basis of his probable cause. So he's going to give a sworn statement, sworn affidavit. The warrant must particularly state the place to be searched and the objects that are the subjects of the search. So, in other words, what are we searching for? So we have to say that where are we searching? Within the definition of the place to be searched, the police may search any area in which they are looking for um, Uh, and what I'm saying, I'm read it again. Within the definition of the place to be searched, the police may search any area in which what they are looking for may be found. So if I'm looking for a kilo of cocaine, I can look as a law enforcement officer anywhere where that kilo may be found. Where could you possibly hide a kilo? So you're talking about something roughly the size of a shoebox or so. So where can we find that? So we're looking in drawers, we're looking everywhere where they can find it. So of course, if they have a warrant to search a home, a certain place where they have the address and they state what they're searching for, um, that means now when they search that place to get the warrant to go search it, they're going to search anywhere where that can be. So that's essentially what they do. So, knock and announce. The police are required under the Fourth Amendment to knock and announce their presence. The police are not required to knock and announce when this will interfere with the enforcement of the criminal law and will prove dangerous or futile or lead to the destruction of evidence. The police are required to wait a reasonable amount of time before forcibly entering into a premises. Warrantless searches. There are various types of warrantless searches that Supreme Court has held are reasonable searches under the Fourth Amendment, including, first and foremost, consent. So, anytime the cops want to search somewhere, the number one exception to the warrant requirement is that if you can give them consent. If you say, "Yeah, go ahead," at that point they don't need a warrant anymore because you told them they can search there. So that's the number one exception. Consent searches. Searches incident to arrest. That's another exception to the warrant rule. But guess what? You need to have to arrest someone. If you're law enforcement, you have to have probable cause to arrest them. So just think of it as that probable cause to arrest now turning into probable cause to search after that arrest. So um, then you have probable cause searches of automobiles. That's what we call the automobile exception, and that's why I tell people, and you probably hear me say it later on in this discussion about why it's dumb to ever carry and just have contraband in your automobile. Worst place. You don't have a lot of Fourth Amendment protection in your car, but we'll talk about that. And then last but not least, and probable cause searches of containers in automobiles. Also consider reasonable are searches of the operator, occupants, and interior of a motor vehicle incident to an arrest or the operator or occupants of that motor vehicle. So that means if it's a search incident to arrest, now they're searching everyone in the vehicle as well. So, search is incident to an arrest. Of course, the police may search an arrestee and the area in his or her immediate control. So, if they pull you over in a car and you got a warrant and they arrest you, at that point, now they're going to search you and they're going to search where the car you just came out of. You just had immediate control in the car, so they're going to arrest you. Of course, you get wherever you get arrested, they're going to search whatever's in your immediate control. So, search is incident to an arrest and the contemporaneous requirement. So a search incident to an arrest must be contemporaneous with the arrest. So you can't wait 2 days and come back as a law enforcement officer. They can't arrest you on Wednesday and say, "Oh, we'll come back tomorrow and just finish search." No, it has to be contemporary. So in other words, they can only search the area that this person has immediate control over, and they must do it right now. So if they're going to arrest me and they're going to search the area that I have immediate control over, they have to do it right now. It must be contemporaneous. Um, this means that the search must be undertaken immediately before the arrest, at the time of the arrest, or immediately after the arrest. So, searches of the area of immediate control and automobiles. A search incident to the arrest of a suspect in an automobile may be conducted when the suspect is in the position to gain access to the interior of the vehicle, or when it is reasonable to believe that evidence of the offense for which the suspect was arrested might be found in the vehicle. When these justifications are absent, a search of an arrestee's vehicle will be unreasonable unless the police obtain a warrant or show that another exception to the warrant requirement applies. So, misdemeanors and searches incident to an arrest. A misdemeanor arrest permits a search incident to an arrest, so it doesn't have to be a felony arrest. It can be a misdemeanor arrest. If they arrest you, they can search you. There's no requirement that the officer reasonably believes that the suspect is armed or dangerous, or that or that the offense for which the suspect is arrested is associated with the possession of weapons, or that there is a risk that the evidence may be concealed or destroyed. In other words, if they arrest you, they can search you. Um, Pretext arrest and searches incident to an arrest. The question is whether there is probable cause for an arrest. An officer's subjective motivations play no part in Fourth Amendment analysis and do not make otherwise lawful conduct illegal or unconstitutional. The U.S. Constitution prohibits selective enforcement of the law based on considerations such as race, ethnicity, or gender. The basis for objecting to the intentionally discriminatory application of laws is the Equal Protection Clause rather than the Fourth Amendment. So if you feel like you're being searched or stopped, and it's because of your race or ethnicity, at that point, um, it's no longer a Fourth Amendment issue. It's actually an equal protection issue. Fifth Amendment Fifth or 14th Amendment equal protection clause. You have those issues. So you can now chat if someone's being racist. Now there's also reasonableness as well, but your beef is primarily going to be that your equal protection rights are violated because you were targeted because of your race. Um, Consent searches. Okay. Consent must be voluntary and not the result of duress or coercion, expressed or implied. So what that means is they can't beat you up and say, let us tell us we can search your crib. In other words, if they do that, that's duress or coercion. So it has to be of your own free will and volition. So in other words, oh sure, Mr. Officer, you can search the crib. I'll have nothing to hide. And even if you do have something to hide, which I don't know why you would let them search. To a lot of people like to consent to searches because they have nothing to hide, or they're trying to play a Jedi mind trick on law enforcement by saying, oh, if I tell the officer to go ahead and search and I have nothing to hide, he'll say, nah, I don't want to search. If you had something to hide, you wouldn't tell me I can search. So obviously there's no reason for me to search. No. Number one rule, the officers want to search. Even if there's nothing there, they take joy and pride and joy in the knowing that they can ransack your crib and look for something. So the moment you say, yeah, you can search, I don't want you to think that they're now not going to search because he said we can search, so he obviously has nothing, so we'll just move on. No, if you tell them they can search, guess what they're going to do? They're going to search. So never, I would say never give consent. And in certain situations, you may not have anything, especially in automobiles or but they're going to come in your house and now going to go through your personal effects or go ransack your house. And guess what? They don't have to do. They don't have to clean up before they leave. So they can come in, turn over your TVs, leave your house in disarray, and guess what? There's no obligation for them to clean up. Matter of fact, they don't have time to clean up. They're going to move on to the next search, or the next suspect. So if they come in your house and you say, "Yeah, go ahead and search," they're gonna ransack your crib and you're gonna, so because you consented to the search, now that means they're gonna actually search. And when they start searching, they're not gonna have any regard for your property, and they're gonna leave it just like they left it. I mean, they're not gonna leave it like it was before they got there. So they're gonna turn your TV over, and because you gave them that consent, and you felt like they weren't going to search because you gave them consent, guess what? They're going to search. So if you don't want to consent to a search, now if you want to consent to a search, by all means do that. But don't do it because because you're trying to play some type of a Jedi mind trick, or use reverse psychology to think maybe they won't search me now that I said they could search me. They're going to search you. They want to search you. So once you get a consent, they're now going to search. So whether or not consent is voluntary is to be determined by the totality of the circumstances. And the fact that an individual is aware of the right to refuse is one factor to be taken in consideration. So if a person is placed in a situation where they feel like if they refuse to search, something's going to happen to them, that's not really voluntary. So and they have to know that they actually can refuse. Like, you can't tell us you can't tell us no. So the scope of a consent search. The standard for measuring the scope of a suspect's consent under the Fourth Amendment is that of the objective reasonableness of objective reasonableness. What would a reasonable person understand by the exchange between the officer and the suspect? So if you say, "Yeah, go ahead and search the whole house," that means go ahead and search the whole house. You said that out of your mouth. If you say, "Yeah, you can search right here in this closet," that means now you've limited the scope of their search. So you've given the law enforcement consent, but you've only given them consent to search right here in this closet. You told them what the scope of the search is to be. Um, then you have withdrawal of consent. Courts require a clear, unambiguous, and unequivocal act or statement of withdrawal of consent. Of course, once you give the law enforcement consent to search, you can withdraw that consent at any time. You can say, "You know what? I don't like the way this is going. Please get out of my house. I no longer consent to a search." And guess what? They have to stop. So at that point, you've now withdrawn consent for the search, and they got to stop searching your stuff. But of course, it must be unequivocal. It must be clear. So you must say, "Hey, stop searching my house. I want you guys to go. I no longer consent to the search. I withdraw my consent." Third party consent. Third party consent may be based on actual or apparent authority, and this normally happens in roommate situations or situations where you have guests at your house, and let's say a guest may come to the door, and actually answer the door when the police come to the door and say, "Yeah, come on in to search." Then it becomes a question of whether or not that person actually had the authority to consent to a search if it wasn't their place. So, but the police officers, they come to the door never knowing who actually owns the place. They just know that this person has come to the door, so they're going to assume that this is a person that has authority to 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 give consent. So they have to figure out whether or not that person actually has authority. So you have actual authority, and then you have apparent authority. That's when it is apparent to the officer based upon how this person's acting or how they hold themselves out, that they have consent to give authority. They are somebody in that house. Um, Common authority and third party consent requires mutual use of property by persons having joint access or control for most purposes. So of course, if the cops want to search a storage unit that you and four of your boys use together, then at that point, that means you have to be one of the boys. It has to be you. You have to have authority to now give consent. Apparent authority, or what we call apparent authority, third party consent, occurs when police officer reasonably but mistakenly believes that a person has that common authority that's required. So, in other words, that person has held themselves out to be someone that has control or common control over the property, and they're now in a position to be able to give consent. So that means it's based upon what the officer dean what is said to the officer and what they believe at that point. So if this person comes to the door and they don't give the officer any reason to believe that they can't give consent, the officer is going to say, "Okay, well, that gave consent. This person is someone that has the authority to. That's why a lot of times smart officers will come and say who owns the house or who's on the lease, because they want the person that has that actual common authority, as opposed to just guessing the first, and assuming that the first person that comes to the door is someone that can give authority. So if anyone's ever been in that situation where you're throwing that house party and you got to know, your neighbors are mad, so they call the cops on you because you got a party going on, and the cops come to the door. A lot of times they'll knock on the door and say, "Hey, who's on the lease?" Get that person and tell them to come out. At that point now, um, they're trying to search for the person who has actual authority. So third party consent and co-occupants. This is when you have roommates. A co-tenant wishing to consent to a search has no recognized authority in law or social practice to prevail over a present and objecting co-tenant. So what that means, if uh, if I have a roommate and me and the cops come to the door and they ask my roommate, "Hey, can we search?" and that roommate says, "Sure, you can search the whole place," and I say no, that the no carries. So that means I've said no. So that means that no, you can't search the crib. So the no always prevails over the yes if there's more than one co-tenant. Um, Probable cause searches of motor vehicles. Um, the automobile exception to the Fourth Amendment, it provides that a warrant is not required to search a motor vehicle, and that's essentially because a motor vehicle is a moving conveyance, meaning that um, because you're in a car that can move. That cop now leaves to go get a warrant. When you come back, they might not be there when you get there. They might. They're more than likely not, if they're smart, aren't going to be there when the cop gets back. So at that point, that is the purpose for the automobile exception. Now they do after that arrest have to still explain probable cause, and what gave rise to their probable cause to arrest you. So don't think just because there's a warrantless search or something that falls under an exception to the warrant requirement that the cops just get away and don't have to explain themselves. They still have to explain themselves. They just don't have to explain themselves up front anymore. So that's all that means. So just a tidbit of advice: you guys are young and you do stupid stuff and you have stupid stuff on you, like drugs. Just to be a smart, well-informed American, there is an automobile exception. That's probably the most important thing I've talked to you about tonight is the automobile exception. When you carry contraband of any kind in the car with you, you are taking a huge risk. The risk in having or possessing contraband of any kind, marijuana, drugs, whatever, is the fact that the risk is all in moving it. So of course, if you're in a situation where and I've seen, I've been driving down the street, and of course, you have young college students. Sometimes at a young age, you're not very smart, you do dumb stuff. I've actually been driving in traffic and looked uh, beside me, and there'd been a car full of young people passing a blunt. Like there's obviously a smoke cloud in the car. These people are smoking marijuana and the car. So all you have to do is roll down your window, and then you can see that okay, you can smell that there's marijuana coming from that car. At that point, of course, the smell of marijuana by itself, the burnt marijuana, is also going to pretty much give rise to probable cause or the reasoning for pulling the person over and now arresting them. But there is an automobile exception. So why would you ever do something so stupid? So just remember the automobile exception. So if you're gonna do stupid stuff, do whatever you do, don't do it in your car because you're not really protected very well by the Fourth Amendment in your motor vehicle. So okay, probable cause searches of containers within motor vehicles. A warrant is not required to search containers within automobiles that may hold the object of the search. Now, the one thing about the automobile exception is you also have the trunk. So, of course, if there's a search incident to arrest specifically, and they're arresting you, and they're going to search where, and you're getting arrested from your automobile. At that point, they can't search the trunk, because they can only search those things that you have immediate control over. So if they're pulling you over and arresting you, um, or they're doing a search, a automobile exception search, that does not require, that does not allow them to search the trunk. The trunk is not within your immediate reach. So if they're now search you because they feel like you have something on you, at that point, the trunk, they're not supposed to search the trunk. Now, if they have reason to believe that what you're carrying is in the trunk, now, there have been cases where there've been surveillance and they watch a person um, put contraband in the trunk. Yeah, at that point, when they pull you over, at that point, and now normally they would have already had some type of a warrant for arrest anyway. Um, but in that situation, they can search the trunk. So in search incident to arrest, they're only allowed to search what you have immediate control over. Um, of course, with the automobile exception, when they're doing that search, that's did so a search incident to arrest, they already have probable cause to search you and where you are, the immediate vicinity of where you are, because you're under arrest. It's different with the automobile exception, so they don't have as much freedom. So, well, it's different with the warrant with the set with the automobile exception, because they have a little bit more freedom. So, other warrantless searches include those where the object of the search is in plain view. Of course, if we're looking at it and we see that there's weed, then I don't have to have a warrant to now search you. Frisk undertaken pursuant to reasonable suspicion, stops and searches under exigent circumstances. So we talked about those exceptions. So my problem with the frisk is, if of course, if I'm being frisked and I'm not supposed to have a gun, and you feel a gun in my pocket, and I'm a felon or something, I can't even possess a gun. And of course, if I have a gun and you pat me down and you pull it and you feel it was obviously a gun, you pull it out. And of course, at that point, I'm in possession of a gun. So at that point, they have other questions to ask. Do you have a concealed permit? Are you allowed to legally conceal this weapon that's in your pocket that we couldn't see? And then two, are you even allowed to have a gun in the first place? Or so in other words, are you allowed to legally have a gun? So all right, inventory searches, also searches that are that fall within the exception of the warrant rule, the warrantless rule. Um, at the station house, it is entirely reasonable for police to remove and list or inventory property found on the person or in possession of an arrested person who is to be jailed. Uh, the contents of an impounded motor vehicle may also be inventoried. Now, the inventory search is essentially to make sure they give you back what they took from you. So if they impounded a car and they have everything in the car, and you had a car radio, you had everything in your car, they want to make sure when they give you that car back, you have everything you have everything it came with. So but once again, cops play that game of cat and mouse. So a lot of times, what do you think inventory searches are really used for? If they can arrest you and impound your car. So in other words, if they cannot give you the opportunity to have someone come pick your car up, if they feel like you're a drug kingpin, they arrest you. You might be something minor like weed. And then of course they're doing the search incident to an arrest, so they can't search the whole car, and they leave the car there. Of course, at this point, they want to find a way to really impact to not allow you to have that car picked up. Because what happens if they can now impound that car, it now becomes inventory, and they almost have to search it, not for the purpose of arrest or the investigation, but they have to do it because of inventory. But guess what? If they find any contraband as a result of their inventory search, guess what they can do? They can use it against you. So if there's a drug kingpin and they want the car and they pull them over and they do just a sweep of the inside of the car, um, where this person is being arrested from because he got warrants or whatever. The next thing they're gonna do is, as soon as possible, they want to get a wrecker, what do you call it, a tow truck out there to impound that car so they can inventory that car to really search it. And that's what happens when they do an inventory search. They're searching the car. So I hope that covers everything. If you have any questions about Chapter 6, searching and seizures of property, just shoot me an email, or message on Blackboard. So um, that you'll have a discussion board. It'll be up Wednesday. So you have your Monday discussion. I mean, the Monday lecture, Tuesday lecture, Wednesday is going to be a discussion board, and then you have a Thursday lecture is going to be posted. So remember, the discussion boards are mandatory. Of course, you graded because that's essentially your participation grade is the discussion board. So you guys take care. Be good.